Well, good morning. For those who may be new to the symposium today, I'm Sam Calhoun, law professor here and Associate Dean for Academic Affairs, and I welcome you to the law school and our continuation of this symposium. This is a real exciting session. We're getting ready to start with our keynote speakers, and when we were organizing this symposium, we were very keen on getting two distinguished keynoters, one on each side of this issue, and we certainly succeeded with our two today, and we're very thrilled to have each of them here. Our first speaker is going to be Professor Caitlin Borgman from the University of New York School of Law. She received her undergraduate degree from Yale and her JD from New York University, where she was an executive editor of the Law Review. She clerked for the Southern District of New York and then litigated for Davis Polk for 4 years, and then went to work for the ACLU, where she served as State Strategies Coordinator at the Reproductive Freedom Project. And she did a lot of litigation in the reproductive rights area and also has written and spoken extensively about reproductive rights. And she also runs and is the editor of the Reproductive Rights Professor blog. So we welcome you, Caitlin. And then our second speaker is going to be Professor Michael Paulsen from the University of St. Thomas School of Law in Minneapolis. He received his undergraduate degree from Northwestern, and then got an MA in religion from Yale Divinity School and a JD from Yale Law School. He worked at the Department of Justice in the Criminal Division Honors Program, attorney advisor in the Office of Legal Counsel. Michael has published extensively in a number of prestigious journals in the area of constitutional interpretation, and we welcome you as well to Lexington and the law school. So, Caitlin.
So I want to thank Dean Calhoun and members of the Law Review for inviting me to deliver this keynote today and for your just absolutely wonderful hospitality while I've been here. Abortion is commonly identified as one of the most compelling moral issues of our time. Politicians and the media describe the debate in dramatic terms, often referring to it as a war. These theatrical descriptions have done a disservice to our public conversation about abortion, in that they have functioned as a conversation stopper. We assume that there are two sides, that these two sides are far apart, and that they are irrevocably entrenched. We are also led to believe that the key moral question in the debate is the value of the embryo or fetus. I argue that these perceptions are false. If we look beyond the hyperbole, we see that most people do not view the issue in such stark terms. The public holds complex and sometimes contradictory views about abortion. For most of the public, abortion seems to present a muddle of potential moral questions. For those who oppose abortion or who favor restrictions on it, the pressing moral issues apparently have very little to do with the moral status of the embryo or fetus and much to do with judgments about women's appropriate behavior and their proper role in society. These subtleties don't make for exciting news headlines, but they are critical for us to understand. We cannot know whether a given abortion restriction makes sense if we don't know what problem or moral evil it aims to ameliorate. Today, I want to begin to untangle the moral knot of abortion so that we can try to have an honest conversation about what is really at stake. In the end, I will argue the moral aspect of abortion that we should see codified in law is a woman's dignity and autonomy in making her own decision about the fate of her pregnancy and thereby her life. I conclude that this concept of autonomy is far better protected by the Roe versus Wade decision than by the undue burden standard of Planned Parenthood versus Casey. This summer, Texas passed a controversial new set of abortion restrictions, as you all probably know, some of which have been challenged in federal court and are now on emergency appeal to the Supreme Court. The federal district judge's opinion in the case described the abortion debate in the dramatic terms that we typically find in the media and in political discourse. Judge Yackel wrote, "Today there is no issue that divides the people of this country more than abortion. It is the most divisive issue to face this country since slavery. When compared with the intensity, emotion, and depth of feeling expressed with regard to abortion, the recent arguments on affordable health care, increasing the debt ceiling, and closing the government retreat to near oblivion. Now, let's just stop for a minute. Is the country really this exercised over abortion? Is the issue more divisive than segregation, than the internment of Japanese Americans, than red baiting, than the Vietnam War? When Texas Governor Rick Perry convened a special legislative session to consider the omnibus abortion legislation, a poll showed that actually 80% of Texas voters did not want abortion to be raised during the special session at all. 63% said the state has enough restrictions on abortion, and 71% thought the governor and the legislature should be more focused on the economy and jobs. In this state's recent gubernatorial election, Attorney General Kenneth Cuccinelli represented an opportunity for voters to choose an ardent foe of abortion. Yet exit polls showed that among Cuccinelli's supporters, abortion ranked a distant third in importance, behind health care and the economy. Judge Yackel's description in the Texas decision is clearly hyperbole. Yet this kind of hyperbole about abortion is so common that we often take it for granted. It is also irresponsible and unhelpful. For decades, the media and politicians have grown accustomed to describing the abortion debate as a heated battle that divides the country. And while this black and white portrayal does not depict reality, the public seems drawn to its simplicity. The abortion debate has fallen prey to the more general phenomenon of news as entertainment. We are more captivated by what Jack Balkin calls the sporting elements of political conflict, the battles, the winners and losers, the polarization, than by the substantive aspects of public policy. Indeed, viewing the abortion battle as hopelessly intractable relieves us from having to grapple with the more difficult questions of what the public actually believes and what that means for abortion policy. Before turning to a closer examination of the public's views on abortion, we might ask why it is that we do not typically have this conversation. The problem is in part that the public debate is dominated by politicians and advocates, none of whom seem particularly interested in focusing on the messy middle of public opinion. Pro-life activists have no interest in highlighting the gulf between their own extreme views and the views of the public. They prefer to gloss over these differences with the vague but appealing term life. I refer to the term life as a Rorschach inkblot. Its meaning is in the eye of the beholder. Life looks at the issue with a soft-focused lens, obscuring the clear moral lines that might offend or alienate the public. The term appeals to people because we're never forced to pin down what it means. Does it mean that the embryo is just like a person, and therefore that abortion is murder? Or does it merely mean that the embryo is biologically alive? Does it mean the embryo has the potential to become a person who has a meaningful life with the kinds of emotional attachments and commitments we associate with our own lives? The soft-focused lens of the term life allows the pro-life movement to avoid staking out a specific moral position. This rhetoric doesn't clarify the moral aspect of abortion at all. Indeed, that is its very point. Abortion rights advocates, on the other hand, often think that it's possible to bracket the moral question of abortion, as Thomas Nagel has put it. They prefer not to have a conversation about the moral status of the embryo because they want people to make up their own minds about it. As a result, they don't challenge the meaning or consistency of a person's statement that life begins at conception. Rather, they tend to simply say, it's fine for you to believe that, but don't impose it on other people. Unfortunately, the public is not too interested in having its own views examined in detail either. The black and white depiction of abortion as a fierce battle is a much simpler and more fascinating story. And the images that the media feeds us seem to support its validity. The news coverage features impassioned politicians and advocates who state their positions in stark, easy-to-grasp terms. We see images of impassioned protesters with signs, and we see fury against abortion translate to violence, when abortion providers are murdered. In fact, though, most Americans do not align themselves with either side in this abortion war. Decades of polling show that the black and white depiction of the abortion debate is not accurate. Last year, the American Enterprise Institute published a public opinion study that summarized polling data on abortion from 1975 to 2011. The study concluded that opinion on abortion has been very stable. It is also deeply ambivalent. While substantial numbers agree with the statement, abortion is murder, there is broad support for the idea that abortion should be a woman's decision. The researchers found that the majority of Americans do not want Roe v. Wade to be overturned, right? The opposite of what we heard yesterday, a substantial majority do not want it to be overturned, but they favor restrictions on abortion, including notification of spouses, parental consent, 24-hour waiting periods, and bans on publicly funded abortion. We need to look more closely at what seems to motivate the public's views on abortion, including the restrictions it appears to support. Good public policy demands a clear understanding of the problem it is supposed to address. Once we understand the problem that the public wants fixed, we can assess questions like whether this is a justification that can validly support a law restricting women's autonomy, whether that justification is based on a sound factual foundation, and whether a given restriction actually furthers its objective. Polls consistently show that Americans do not want to ban abortion, although they do support many restrictions on it. It's not just polling data that demonstrates the public's unwillingness to ban abortion. Even states like South Dakota and Mississippi that have led the nation in passing onerous and creative new abortion restrictions have not been able to get voters to approve embryonic personhood measures or abortion bans through ballot initiatives. It is perhaps even an open question whether the public would, if asked to vote directly, support many of the less extreme restrictions we are seeing today. As I mentioned, the Texas omnibus abortion bill was highly unpopular according to polls. Similarly, so-called partial birth abortion bans were perceived to have broad public support, but on the few occasions when the public was invited to weigh in directly on the issue via ballot initiatives, voters rejected the bans. Nevertheless, polls do show that the public supports, at least in theory, restrictions like parental involvement laws, waiting periods, and funding bans. What might account for this? The public's opposition to abortion bans, coupled with its support for the lesser restrictions, shows that the public does not view an embryo or fetus as a person or abortion as murder. Polling results confirm this, especially as to the early stages of pregnancy. For example, most Americans are morally unconcerned with the destruction of human embryos in contexts other than abortion. Large majorities of the public in a recent Pew Research Center poll thought that non-abortion procedures that involve the destruction of embryos, including embryonic stem cell research and in vitro fertilization, are either morally acceptable or are not a moral issue at all. And even as to later stages of pregnancy, the public supports abortion in circumstances that are incompatible with viewing a fetus as a person. What then could be driving the public's support of abortion restrictions? One could say that the public believes that that embryos and fetuses have value, just not as much value as a person. This would mean that the state's power to protect them might be outweighed in certain circumstances. Certainly, this could explain why the public would tolerate or support some restrictions. But the embryo's moral value doesn't change depending on the woman's reason for obtaining the abortion. Therefore, we must still account for how the public distinguishes among those restrictions or considerations that outweigh the embryo or fetus's right to exist and those that do not. This is especially so when it comes to restrictions on early abortions, since the public apparently places relatively low value on embryonic life, as evidenced by its lack of concern for the destruction of embryos in other contexts. Virtually all of the common restrictions that states have imposed on abortion since Roe are the product of a pro-life movement strategy to dismantle the abortion right one incremental step at a time. A major goal of the incrementalist strategy has been to create public disfavor for abortion by making it disfavored in the law. This is reflected in a strategy memo written by a key player in the anti-abortion rights movement. Thus, pro-life movement leaders have supported measures like requiring parental involvement in minors' abortions decisions or making women wait 24 hours before getting an abortion. Incremental restrictions are designed to insidiously chip away at the constitutional right to abortion. They are usually promoted under some other justification than stopping abortions, such as protecting women's health. There are two possible reasons why the general public may support such incremental restrictions. One is that the public may be led into thinking that the stated justifications are sincere and grounded in fact. The other is that their support is influenced by the black and white rhetoric that abortion is wrong. Let us consider each in turn. Most incremental restrictions are premised on some implicit or explicit factual assumption about abortion, women, or abortion providers. For example, parental notice requirements suggest that most teens don't voluntarily talk to their parents about abortion and that a law will make them more likely to do it. In fact, both of these assumptions are false. Similarly, so-called informed consent requirements are often justified on the grounds that abortion is physically dangerous, for example, because it causes breast cancer or increases a woman's risk of suicide. Neither of these assertions is backed up by science. Moreover, abortion is one of the safest medical procedures, with less than 0.5% of patients experiencing a major complication. Targeted regulation of abortion providers and facilities, also known as trap laws, are based on the false assertion that abortion is poorly regulated and performed in an unsafe manner. An example of such a law is the Texas requirement that abortion providers have admitting privileges at a nearby hospital. This restriction wrongly implies that abortion patients will often end up in emergency rooms and that most other providers of outpatient procedures have such admitting privileges. Trap laws ignore that abortion is not only exceptionally safe, but is also one of the most heavily regulated of medical procedures. If the public accepts the false factual assertions made in support of these restrictions, they may support them because they believe they are really protecting women. Another possible explanation for the public's support of incremental restrictions has more to do with the black and white rhetoric denouncing abortion. These portrayals fuel vague, poorly thought out moral impressions. Abortion is bad. We're not sure exactly why, but we know that it's morally questionable in some way. Therefore, women who get abortions must also be bad. Likewise, abortion providers must be shady and out to make money by preying on women. Most of the incremental restrictions feed into this generalized disapproval of abortion. Trap laws are needed to rein in crooked abortion providers. Waiting periods are needed because pregnant women are irresponsible and need to be forced to reflect on the gravity of their behavior. In fact, much opposition to abortion seems rooted in a belief that abortion encourages or excuses women's sexual irresponsibility. Abortion is an easy way out for licentious or rash behavior. People may also find unsettling or off-putting the idea that a pregnant woman would reject motherhood. Enduring the burdens of pregnancy, childbirth, and parenting is how women can make amends for poor choices about sex. Incremental restrictions fit this pattern. Many of the restrictions seem intended to make abortion less easy or appealing for women by imposing burdens that we do not impose when a woman chooses childbirth. Spousal or parental notice requirements suggest that women are not capable of making a responsible decision on their own, or that they can't be trusted to consult family members voluntarily. Funding bans ensure that poor women bear the financial consequences of their irresponsible behavior. Pre-abortion ultrasound mandates amount to a kind of shaming process in which the women's own bodies are used to show them the visual evidence of their guilt. The theme of women's irresponsibility also explains the popularity of certain exceptions to abortion bans. Polling shows that the public is most sympathetic to abortion in cases of serious endangerment of the woman's health, grave fetal anomalies, and rape or incest. What all of these have in common are circumstances beyond the woman's control. Health crises and fetal anomalies offer reasons for the abortion besides an easy way out from the burdens of motherhood. They suggest that the woman would embrace pregnancy if only she could. They also show that while we expect women to bear the burdens of pregnancy, childbirth, and perhaps parenting, there are some burdens that we think are too much. Cases of rape and incest demonstrate most vividly the theme of irresponsibility or culpability. Women who become pregnant as a result of voluntary sex are guilty. They caused their own predicament. Women who were raped are innocent. To make them bear the burdens of pregnancy and childbirth would be unfair. These inferences, of course, are just that. It's hard to know exactly how the public feels about abortion restrictions because the people pushing for these restrictions, which are most definitely not the general public, don't care to know. The point of the incrementalist strategy is to increase opposition to abortion no matter the reasons. This is where we see the black and white rhetoric against abortion weakening our public debate. We see public policy being formed based on simplistic declarations unmoored from the inevitably more nuanced facts. Normally, we should diagnose what social problem we are trying to fix before we decide how to fix it. Instead, abortion restrictions are enacted based on disingenuous sound bites and factual falsehood that activists advance and the media dutifully repeats. The congressional legislation to ban abortion at 20 weeks of pregnancy, passed by the House and introduced by Senator Lindsey Graham this week, is a perfect illustration of this. The ban is based on the scientifically dubious claim that fetuses can feel pain at 20 weeks. Senator Graham suggested that it is at this stage that you become you. At the same time, both the House and Senate versions contain exceptions for rape and incest, exceptions wholly inconsistent with the entire premise of the bans. This is no way to do public policy. Obviously, we ought not to be passing laws based on false factual premises. And the judgments about women that I've just described are equally troubling as bases for legislation. Why are these moral judgments about women not permissible foundations for law? First, the law must be based on reason. We have to demand consistency. We can't say, here an embryo has value and here it does not. Second, to try to codify moral judgments this nuanced is a hopeless task. The law is a blunt instrument, and we will often find that it produces unfair results. For example, who are we to presume that women having an abortion are rejecting motherhood when the majority of women who obtain an abortion are already mothers? And many are doing it precisely to protect existing children. Many women are having an abortion so they can be able to have children when they are financially able. And finally, whatever moral opinions we have about whether women are making a good decision to have an abortion are overridden by a far more important moral imperative, honoring the dignity and autonomy of women. Women choosing abortion are indeed making a moral decision. They are making a decision that reflects significant, conscientious deliberation over how best to govern their lives. Far from being irresponsible, women choosing abortion are doing so because they believe it is the most responsible decision they can make. However we may feel about the fact that a woman is unintentionally pregnant, and let us not forget that a man helped cause this predicament, we ought to applaud her for making the most prudent decision she can in light of that circumstance. At the very least, we should respect her right to make that decision. We allow people to make important moral decisions in other contexts all the time, even if we don't agree. For example, we allow people to decide to have another child when they already have many, and when the new law might stretch the family's resources and ability to provide for their existing children. We might have a moral opinion about this, but we don't think it should be made illegal. Let's consider where Roe v. Wade comes down on the issue of women's autonomy. We've heard plenty of criticism of Roe during this symposium, and my purpose here is not to defend Roe's reasoning or its stated rationales. As Professor Myers pointed out yesterday, there are many, many Supreme Court decisions that we respect as important precedents, even though we find their reasoning imperfect. Rather, what I'd like to look at is the frameworks of Roe and Casey and the extent to which they advance or inhibit women's autonomy and dignity. The Roe opinion may lionize doctors, but Roe's framework protected a woman's autonomy by leaving to the woman the decision whether to continue a pregnancy up until the point of fetal viability. Fetal viability marked the earliest moment when the state could impose its moral view on the woman. Before this, a state could regulate abortion only to protect women's health, and the strict scrutiny standard ensured that disingenuous claims to protect women's health would be ferreted out. Now the governing framework is the undue burden standard established by Planned Parenthood versus Casey and as further interpreted by Gonzalez versus Carhart. These decisions have weakened protection for women's autonomy in two ways. First, they have expanded the permissible reasons a state may regulate abortion before viability to include moral opposition to abortion. In addition, the scrutiny applied to such regulation has been weakened. This allows states and pro-life advocates to promote and defend these restrictions based on disingenuous reasons and misrepresentations of the facts. Casey has thus helped to impoverish our public debate about abortion. It has encouraged the superficial, unthoughtful treatment of the abortion issue. Abortion is cheap ethics. It's too easy. We get to point our finger from the comfort of our chairs. We don't have to put in a lot of thought, and we don't have to make sacrifices. It's much less satisfying to see abortion as a nuanced, complex moral decision, not well suited to bright legal line drawing. It's harder to acknowledge that the problems affecting women that really cry out for our attention are daunting issues like poverty, job discrimination, racism, homophobia, rape, and domestic violence. But it's been 40 years since Roe v. Wade was decided. This country is not at war over that decision. This country is ready to move on, to attend to the unfinished task of ensuring that all women are treated as full, equal, and respected members of our society. Let us turn our attention to that.